The ODC filed 6 counts of formal charges against respondent, alleging that his conduct violated the following provisions of the Rules of Professional Conduct. Rule 1.3, failure to act with due diligence and promptness in representing a client. 1.4, failure to communicate with a client. 1.5, fee arrangements. 8.4c, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. And 8.4g, failure to cooperate with the ODC in its investigation. Respondent filed an answer and the matter was set for formal hearing. At the hearing, respondent stipulated to the allegations of misconduct, so the hearing was limited to the question of the appropriate sanction. Respondent testified on his own behalf. He expressed remorse for his failure to communicate with his clients and the ODC and admitted he could have handled the matter more professionally. He attributed much of his problems to the lack of an adequate office staff and calendaring system, which he stated he had rectified. Based on defendant's stipulation, the hearing committee found the ODC had proven by clear and convincing evidence violations of Rules 1.3, failure to act with diligence and promptness in representing a client. 1.4, failure to communicate with a client. 1.5, failure to return unearned fees. 8.4c, engaging in conduct involving deceit, dishonesty, fraud, or misrepresentation. And 8.4g, failure to cooperate with the ODC in a disciplinary investigation. The committee found respondent's conduct reflected badly on the legal profession. As a sanction, it recommended that respondent be suspended from the practice of law for a period of 1 year with 6 months deferred, subject to a 2-year period of probation with conditions. The disciplinary board adopted the hearing committee's findings of fact. It further concluded respondent violated duties owed to his clients and the disciplinary system. The board found respondent's conduct caused actual harm to his clients because their cases were delayed. It noted Ms. Cadwallader in particular suffered financial hardship because respondent failed to pursue her child support matter. Moreover, it pointed out that the disciplinary system was harmed by respondent's repeated failure to cooperate with the initial disciplinary proceedings. In addressing the issue of sanctions, the board found the baseline sanction under standards 4.42 and 7.2 of the ABA's standards for imposing lawyer sanctions was a suspension. As to aggravating factors, the board recognized respondent's prior disciplinary offense pattern of misconduct, multiple offenses, substantial experience in the practice of law, and failure to cooperate in the initial disciplinary process. As to mitigating factors, the board considered respondent's remorse, character and reputation, cooperation, attitude through the submission of previous consent discipline petitions, and absence of selfish motive. Is that fast?
No, I don't know. I think I was trying to write so cleanly that I